Welcome to Estate Planning 101, provided to you by Hunter Estate and Elder Law. This presentation is designed to provide a brief overview of estate planning, what it is, what documents are involved, what roles and capacities are involved. So let's dive in. Who is in charge and when? All of these capacities, power of attorney, trustee, healthcare proxy, executor. Let's begin with healthcare proxy. A healthcare proxy is a document that you name someone to make healthcare decisions for you if you are unable to make them for yourself. This person is often referred to as your healthcare representative. The healthcare representative not only makes healthcare decisions for you, but they also coordinate organ donation as well as enforce your living will declaration. But wait a minute, what is a living will declaration? A living will declaration deals with one thing and one thing only. That is end-of-life treatment and medical decisions such as artificial nutrition and hydration. So for example, in your living will, you state you do not want to rely on artificial means to be kept alive. Your healthcare representative enforces that decision. But do know, and this is something a lot of individuals do not realize, that your healthcare representative actually can override your decision in your living will declaration. Lastly, a healthcare proxy allows healthcare professionals to freely communicate with your designated healthcare representative. There is a little thing in the healthcare industry called HIPAA, and the purpose of HIPAA is to keep a patient's health information private. Therefore, someone off of the street can't waltz into a hospital and inquire about a total stranger. So a healthcare proxy often includes, and it should include, HIPAA language, which will allow your healthcare representative to openly communicate with your healthcare professionals. Next, power of attorney. A power of attorney is a document that grants someone else the authority to act on your behalf with regard to legal and financial matters. So let's reverse. So like the last slide was in regard to healthcare decisions, right? A power of attorney deals with the opposite. They deal with the legal and financial decisions. This document, the power of attorney document, grants a significant amount of power because it gives the designated individual the power to sign your name. For example, if I give you a blank check, what could you take from me? Everything in that checking account, right? Okay, if I give you a power of attorney, if I make you my power of attorney, what can you take from me at that point? Everything. Oftentimes we use this example not to scare you, but instead to make sure that you are putting an appropriate person in the power of attorney position and to be sure you understand the power behind this document. Next, executor. So if someone passes, an executor is who is named in that person's last will and testament, and is also who is in charge of getting through that person's estate. But here is the thing. If you have a will, your estate may go through probate, which is a court proceeding that takes place after someone passes. But it may not go through probate. And it all depends on how assets are owned, because a last will and testament only controls assets that are held in the individual's name alone. So for example, assets that are jointly owned, so two or more names on the asset, beneficiary designated, such as life insurance or retirement accounts, or trust-owned assets, do not go according to the will. We often tell clients, you could have a will plated in gold, but if everything you own is jointly owned, beneficiary designated, and or trust owned, your last will and testament will not control. So what happens though if your will does control? The probate court is who officially appoints the executor. So when someone passes, the person listed in the will as the executor has no power until they are actually appointed by the court. For example, say you are in the will as John Smith's executor, and you want to sell John Smith's house right now, but the court has not officially appointed you as the executor. They're dragging their feet. Maybe the lawyer dragged their feet. Regardless, you do not have the authority to do so. You will have to wait until you're actually appointed by the probate court. And while we're talking about probate, I want to take a minute and talk a little bit more about it because we get many questions of what it is, what is involved, etc. We often say probate is somewhat like the land of the unknown, but there are certainties about it. First, it takes time, and sometimes a lot of it. Not only is there much back and forth between the proposed executor, the attorney, there's court paperwork that needs to be prepared, there's the filing to the court, but there's also an automatic delay of 3 months when probate is actually officially open. And that 3-month delay allows creditors to make claims on the estate, regardless if the individual passed has creditors or not. A second certainty is that it is going to cost something. You have to have an attorney to go through probate. You cannot do pro se probate. So if you have to have an attorney, there will be legal fees, likely. There will also be court costs. And if a beneficiary tries to contest the will, or someone comes out of the woodwork, hence the land of the unknown I mentioned, you are likely looking at more time and more money. Lastly, a third certainty is that probate is a public process. It's through the court, and anything through the court is public record. Finally, on to trustee. Let's start though with figuring out what a trust is. There are several types of trusts, but in general, a trust is a private document that allows you to, for example, bypass probate. It can get asset protection against long-term care, get asset protection for small business owners or farmers. It can minimize taxes. The list of advantages of a trust is endless. A trust allows you to create rules for life, disability, and after death. And your trustee, who is the individual who is in charge, or commonly we refer to them as the manager, they must follow those rules, the rules for life, disability, and after death. So it is common that the trustee of a trust is you, or you and your husband and wife, until you reach a point of disability or after death when the baton needs to be passed to a successor trustee who you have named in that trust document. Now, trusts are also a popular instrument to pass on values, education, family, etc. For example, we see grandparents want to create a little mini fund inside their trust for their grandchildren's college costs. Or we see parents who leave their children's inheritance inside a trust, opposed to giving them a check issued straight into their name, because they want it protected against a possible divorce or creditor or bankruptcy proceeding. But regardless of how custom you make a trust, whoever the current serving trustee is who is in charge of abiding by the terms of that trust. And they must always always act in the best interest of all current beneficiaries. We did it! We have now gone through trustee, power of attorney, executor, healthcare proxy. But what is important to remember here is that without documents, none of these exist. You do not have anyone serving as your trustee because a trust would not exist. You don't have anyone serving as your power of attorney because that document would exist. And so on and so forth. So it is important to not only consider the who of all of these roles, but also take the time to get your planning done. If you have questions on where to begin in the estate planning process, we promise we can help you take the first step to begin the journey with comfort and ease. Just click the box below and we'll be in touch to schedule a free discovery session for you and your family to get your planning in place and protect yourself and the ones that you love. We encourage you to start the process today. Thank you for listening.